Attorneys for former President Donald Trump made oral arguments before a federal appeals court in Washington this morning with two key arguments. The 2024 Republican presidential frontrunner has presidential immunity from special counsel Jack Smith's charges, and that President Biden is, quote, prosecuting his number one political opponent and his greatest electoral threat, end quote. Now, the panel of the three judges, two of whom were appointed by President Biden, appeared skeptical of the immunity argument as they questioned attorneys for former President Trump more aggressively than the representatives for the special counsel. But there may be another issue here. Is Jack Smith, the special counsel, legally operating? Does he actually have the authority to do what he's doing? Join me now to discuss this is Gene Schaerr. He's a former White House associate counsel to the president and served as a law clerk for two U.S. Supreme Court justices. He is now a partner in a law firm here in Washington, D.C. Gene, welcome to Washington Watch. Good to see you.
Good to see you, Tony, and thanks for the invitation.
Well, let me first get your reaction, your general reaction to today's hearing.
Well, I agree with you that certainly two of the three judges were quite skeptical of the arguments made by President Trump's lawyer. And if I had to predict, I think that they are likely to send the case back to the district court for a trial. And then, of course, President Trump's lawyers will have the option of seeking review of that decision, either from the full D.C. Circuit, a proceeding that we call an en banc review, or they can go immediately to the Supreme Court and seek review of that decision there. But it seems quite likely that Trump is likely to lose at this phase.
Is that because of the court makeup?
Well, it's not even clear that he will get the vote of the third judge, who was a Republican appointee. She didn't seem as sympathetic to his arguments as I would have expected, but of course we don't know for sure until the court actually decides. But I think it was so it may not be just the result of the court's makeup. It was. The argument that was made against Trump here is a technical argument that this is not the kind of a case that is appropriate for immediate review. The general rule in our legal system is that you have to wait until there is what is called a final judgment before you can appeal a ruling. And the argument is that as of right now, there's no final judgment because Trump hasn't gone through trial and there hasn't been a final decision as to whether he is guilty or innocent of the charges that have been made against him. And so the argument on the other side is you shouldn't. The argument that was made by one of the amici was that you shouldn't take this case at all because there's been no final judgment.
So in other words, you're getting the legal cart before the horse.
That's a good way to put it, yeah.
All right, so let's talk about something else that you filed a brief, friend of the court brief, that may actually be a bigger issue here, and that is regarding the special counsel and whether or not his appointment was constitutional. Talk about that.
Yeah, the argument that we made in an amicus brief, a friend of the court brief filed on behalf of former Attorney General Ed Meese and various others, is that Jack Smith simply doesn't have authority to prosecute President Trump or anybody else because he was not properly appointed pursuant to any statute. The general rule under the Constitution, under Article 2, Section 2 of the Constitution, is that only Congress can create officers of the United States, and they have to do that according to statutes. There is no statute that authorizes the appointment of Jack Smith to exercise the kind of power that he's exercising, the power to prosecute a former president with any degree of independence from the Justice Department or anybody else. Now, there is a way that Attorney General Garland could have properly appointed a special counsel. He could simply have appointed one of the sitting U.S. attorneys who have already been nominated by the president and confirmed by the Senate. That would be a proper way of proceeding in this prosecution. But instead, for some reason, Attorney General Garland picked Jack Smith, who had not gone through that process. In fact, he was simply a private citizen at the point at which he was appointed to that position. And there's just no statute that authorizes the Attorney General or anyone else to appoint a prosecutor in those circumstances with the kind of independence that Jack Smith enjoys.
So, Gene, has that ever happened before?
Yes, it has happened. It happened in the case of Robert Mueller, and many legal scholars whom I admire, including two of the signatories to our amicus brief, Gary Lawson and Steve Calabresi, who are good friends of mine and very well-regarded law professors. They argued at the time that Mueller's appointment was unconstitutional because there was no statute that justified his appointment, and so the same argument would have applied there.
So these may sound technical, but they're quite significant because, for instance, if I want to challenge something that the federal government might be doing, I have to determine that I have legal standing. So it's applied to me. So the person who would be prosecuting needs to have the legal foundation to be doing that.
Absolutely. And, these rules that were set up by our framers may seem technical and may seem procedural, but all of them were based on important principles of good governance. And in this case, the principle at issue is the proper separation of powers between Congress and the executive. That the appointments clause that I mentioned earlier in Article 2, Section 2 was put there by the framers to ensure that Congress, composed of the people's elected representatives, have adequate authority and oversight over the positions, over the officer positions that are available in the executive branch to be filled, so that you don't have somebody, so that the president doesn't have the ability,
Right.
for example, to operate like a king.
It's the rule of law. Our system works on that. Very, very quickly, Gene, we're up against a break, but do you expect the court to entertain that argument?
I don't expect that they will entertain it here because President Trump's lawyers have not expressly adopted it. They've indicated they may adopt that later on, but they have not yet adopted it.
All right. Gene Schaerr, I want to thank you for joining us. Very insightful. Appreciate the analysis.
Good. Pleasure to be with you, Tony.